Case number 25S00791. FY, People State of Michigan versus Timothy Dansby.
Zachary on behalf of people.
Illinois, 87446, standing in for the attorney of record, John Zonlin, and appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Yes, my name is Timothy Dansby, and I'm about to represent myself, and I'll take counsel as an assistant, you know. But I don't know who this being is. I never signed for no representation as counsel, so.
Okay, you don't want a lawyer?
You
don't have to have one.
I'm gonna need somebody, because apparently I can't get a hold of no paperwork I haven't received by Discovery.
Well, that's what we got lawyers for, sir.
To the counsel machine to get to the lawyer very well within the county. So it's paying me hard, so I'm gonna need some type of system.
Okay, well, that's what we got for you. Okay.
I'm gonna be representing myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I wanna go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge, let's see.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a flappy mouth.
I got a brain to go with you.
Well, you can have a, but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. So if nobody said you don't have a brain or anything, you just need to stop talking. And
I'm going to go out on a limb here and say that even though this guy has 2 ears to listen, he's still lacking the brain to process what you're saying. But that's just my observational opinion.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing, where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. All right. So you understand all that? Now you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dansby today, and have not received any audiovisual discovery from my understanding.
I like to down if you don't mind. About the motion, you know what I'm saying, for the fact that I haven't been denied. You know what I'm saying? And it's happening now. You know what I'm saying? When the prosecutor was conduct, we should my government check. Even though it's
okay, that's a lot of talking. Where's the prosecutor? Yeah, but where's the prosecutorial misconduct?
Well, I should have had my discovery, y'all.
Sir.
And you'll get all the discovery as soon as the prosecutor has it, just like the judge said.
That's worse. Well, no, you shouldn't have had your discovery because this is the first hearing.
So in the first hearing, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just like, oh, yes, come on, this is not slavery. This is not the one, young. I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
I don't even have a license. What's your license number?
First of all, I don't know who you think you're talking to. But do you want to spend an extra 30 days in custody? No, you don't. You don't care. That's why you're here charged with something.
What is your license number?
I don't have to answer you, and I don't answer to you. And I'm not going to start now. You need to settle down. You need to settle down. Okay, take him out of here, please.
All right, So, the judge sent the inmate back to his house, but she had a conversation with the defense attorney. For a few minutes. I'm going to leave this part in as sometimes we don't realize that old and experienced attorneys always had that one difficult client when they were new.
He's having his moments. So we're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right, so we'll give you what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's gonna want to see it, so you probably gonna need to have him take a
I will
laptop over there to the jail and take his license to practice law to it. Okay. All right. So the next probable cause conference on this charge is gonna be.
I just, to make a record as regards to that discovery, I do have paper discovery, which Sister Counsel has noted that has been tendered already. I do not have, it does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30, and hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Gonick will be in trial in the Wayne County Circuit Court. I can make that big work for myself if you're wanting Mr. Gonick to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance that I would be more comfortable with Mr. Gonick because he handled his own.
Well, you know what? You gotta cut your teeth somehow. We've all had this.
Just don't know.
Ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got this Gracie. He's an expert in this.
I've had my share over the years when I was licensed to practice law. So, by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more.
Unfortunately, Judge, he comes back a few weeks later and hasn't settled down at all.
This is case number 25S00791FY, People State of Michigan versus Timothy Dansby.
Sure, on behalf of the people. Morning, Your Honor. Ben Gonick, here on behalf of Mr. Williams.
Okay, Mr. Gonick, good morning. Sir, come on. Can you get up? Can he move? No? Okay, sir, can you tell us your name? All right, so Mr. Dansby, today is the adjourn date for a probable cause conference on this charge of this was a retail fraud, first degree. And so last time, Mr. Gonick, you needed some video discovery and you wanted to review all that. So did you get a chance to do that? Okay. Well, he didn't apparently, but did you look at it?
I did not receive it.
Okay, what happened with the video discovery?
I wasn't here in this case.
Huh?
I don't see it even in my file, so, what I can tell the court is, actually, this is next day. I'll get it today instead of.
Oh, all right. Well, things might have slowed down since she was off. Okay, so you want an adjournment, Mr. Gonick, again? A brief one? I don't know. How long would you like?
Pardon me?
How long would you like it to be?
We have a trial next week starting in front of Judge Rowe, but it's only going to be a couple-day trial.
Okay.
So,
Okay, sir, put your hand down. Put your hand down. Okay. The following week.
yes.
What do we have the following week? Not next week, but the following week.
Or just another
Not another PCC.
for 8th at 9:10.
How about September 8th, 9:30? We'll get to you in just a second, sir.
The only problem I have is that my trial starts on the 4th. It should be done the 5th, but that's Judge Rowe's criminal call, so that'd be
So he won't be doing it during that.
trial. That's
Yeah.
trial. That would be
September 8th at 9:30 then. Now, what do you want to say, sir?
I think, Your Honor, that, first of all, this is supposed to be an examination, but I'm not asking for German. I'm asking for more. I also want to state that this lawyer is being forced on me, because I can ask for one. I haven't signed for no attorney to be represented, so I don't know why he adjourned something where he's not even, I don't even have him to represent. I mean,
How are you going to get the information?
I don't get the information, well, I said, thank you,
Sir,
bring it to me and review it.
okay, the prosecutor ain't going to bring nothing to the jail.
Think about what the law said. I'm going by
Okay.
what he did.
I don't know what law you looking at. Okay, but the prosecutor's not going to bring you.
But I'm an inclusionary member of the bar by the constitutional right. I have the right to be free and prosecute myself by the Constitution of the United States Constitution, which is the highest law of the land.
All I got from that word salad was that the Constitution of the United States overrides court procedure. Now, this is the first time I've ever heard the Constitution of the Constitution. So let's see where this fictitious document takes us.
I don't even know if we are even practicing law. I don't even know if you like to practice law.
What they're doing don't matter. They're not on your case, sir. I'm not trying any facts. Okay? Number one.
Represented by legal lawyers, not persons who impersonate lawyers.
Okay, stop. You finished now?
No, I'm not. You're slowly stop. I'm not finished.
Okay. Well, you're finished as far as I'm concerned. So this is what I got to say to you. First of all, we don't allow anyone to practice law that's unlicensed.
But that's not true.
Okay. Let me just, I don't do it in this courtroom. Okay, sir, would you stop talking of Wolf? I have to have you taken out of here? Because you don't listen. You don't listen.
I have a constitutional right to represent
Charles.
myself.
Now, what I'm trying to tell you is this. The prosecutor can't bring you a video. And the video could be the crux of the case. We don't know what it shows. Your lawyer would be derelict and the person here, this is the lawyer that's here, that's been assigned. Okay? So, he would be derelict in duty if he didn't get it, to look at it, and to try to ask. Well, he doesn't have it yet, sir. And then he can ask, and
I'm asking for this due process.
okay, first of all, there's no basis.
In a timely manner.
The motion's denied. There's no basis to dismiss the case. Okay? Not right now, there is not. And so he can ask to bring his computer into the facility to show you the video. If he gets it, which apparently the prosecutor didn't have it. This is the normal prosecutor.
I don't know.
Okay.
Let's try what for the court.
Okay, well, I'm just explaining to you. I don't know who lied or who didn't.
They never got one because they never intended to go this far. They didn't think that I was going to go this far. They didn't I'd come back down.
Okay. Well, guess what?
It's something I did not do.
Nobody asked you to take a plea. First of all,
I'll tell you what he asked.
First of all, he might have asked you if you wanted to. I don't know what he said. That's between you and him. But the bottom line is, he doesn't even have all the information to make a determination.
But they asked me what he
Okay, I don't know. I said I don't know what he asked you. That's between you and your lawyer. That's not.
Conversations between you and your lawyer are privileged and private and should stay that way. And if you do decide to represent yourself, then I guess the conversations that go inside of your empty skull should stay there as well.
At least not here, because I'm not taking a plea on this particular case, even though I probably could take a felony plea. I'm not doing that. We're just here to see what's going to happen as far as the discovery and if we need to hold a preliminary exam or not.
It's not gonna be, it's not gonna be. Well, see, because this is supposed to be my examination. It's not-
This was not your exam. This was a probable cause conference date. All right, we haven't set the exam yet because we haven't gotten all the information to set it. So we're going to go ahead and get the information and we'll make a determination if we're going to set it just in the next week when we come back. So that's what we're going to do. And you need to calm down. Okay? Fine is continued.
I'm trying to, right, I already know I get a little animal.
Yes,
That's when I know that I can
but then the truth will come out.
about none of that because these people are trying to prosecute.
The truth will come out, sir.
And I'm not going for it.
Okay.
Going on with that.
All right.
Thank you.
We thank you. All right. Fine. Let's continue.
I go.
We'll see you back here on the 8th, 9:30. That's another PCC.
All right, so that's the end of the second hearing, but he'll be returning in a couple of weeks to disrupt the court and spew more of his poor me vomit all over the record. Next, we head to Judge Goggins' courtroom where we have a sovereign citizen who appeared yesterday and apparently woke up from his nightmare of credit card debt only recently. I assume it was sometime after. He read on the internet that you could just wave a magical sovereign citizen wand and your debt will disappear into thin air.
Mr. Jamal, let's just do your second one, your Citibank versus John Hayes.
Yes, and good morning, Joseph Jamal here on behalf of the plaintiff.
This is file 2425, and I've got another gentleman here, John Michael, who apparently has filed paperwork.
Yes.
Mr. John Michael, you've got semicolon Hayes, respondent. First of all, are you an attorney?
I am not.
Okay. So do you have, you're alleging in, I guess, all these documents that you're somehow a representative for John Hayes. Is that right?
That is correct, sir.
So how are you, or it says beneficiary, do you have some paperwork giving you some authority to act for John Hayes today?
And the UCC one that was filed.
But no, is there an order, court order? I understand the rules and the statutes and the laws, but do you have anything that says, listen, you've got authority?
I have nothing other than the process of the United States Corporation
I
that
see.
committed started the trust in my name.
Who started the trust in your name?
The Corporation of the United States of America after its bankruptcy.
Oh, you went through a bankruptcy?
No, the United States of America, the corporation did.
Oh, I got you. But you have nothing that says you can represent John Hayes then?
I'm not acting as surety for John
Okay.
Hayes, that is for sure.
All right, so we've got a motion to dismiss. I don't have an attorney that's filed a motion to dismiss. I guess, Mr. Jamal, let's hear that first, I guess.
Your Honor, I guess my understanding, you said motion to dismiss. Is that for plaintiff's motion for summary
Yeah.
judgment you're referencing?
Well, you've got your summary, disposition motion that's out, but he's got also, it looks like his motion to dismiss, defendant's motion to dismiss. That's one I think is probably easier to deal with first.
Okay.
I don't even know what it, but frankly, it is, but you did respond to it, it looks like. Plaintiff's response to defense motion to dismiss. Anything you want to tell me on that one, I guess?
Nothing further, but for the fact that, based on my understanding of the court rules, everything was filed as required by the law. No actual documentation is required with the notice pleading state, of which Michigan is. Notice is provided since we have provided detailed account documentation supporting our claim. So I think his motion to dismiss related to failure to state a claim and lack of subject matter jurisdiction should both be denied.
Okay.
I object
And
to
Mr. Mr. However you want to refer.
I think his name is John Michael of the family sniffer, beneficiary of some really bad information on the internet. Say yes? Sir, if you agree.
Tell me about your motion.
Well, I asked all of the parties involved for validations, and I sent a statement of facts, and none of which were responded to, so that would be acquiescence to the truth of my statements, which should stand in truth and commerce. I asked for a contract and demonstration where there was adequate consideration giving, and did not receive any of that. It's my understanding that the consumer credit transaction or the application was taken by the Citibank and Best Buy to securitize the collateral to the Department of Treasury for their funds. They were paid, and now they're asking for me to pay in addition to that. I did not realize any of this was true until recently. And now if I am continuing to be required to make payment in any form of negotiable instruments, they are, in my opinion, are being unjustly enriched. They have never given me a contract with a signature. They've given me valid verification by bills and statements, but never anything that would demonstrate that they ever had anything at risk or that they lost anything. Therefore, without a contract, there is no standing, there's no claim to bring remedy to.
You find there's been significant number of documents that have been filed, one being the motion to dismiss this matter. It's signed John Michael, Hayes beneficiary. I've got no indication that John Hayes, whose pleading this is filed against, is in fact here. I've got no attorney representing John Hayes. I've got some allegations that John Michael... Hold on, sir, it's my turn. Sir, it's my turn. John Michael is somehow representing John Hayes. That's one problematic point with the motions that were filed. It's got a notice of special appearance, but I can't have a special appearance without some authority from John Michael. I did get a chance to review, nonetheless, all the documentations with regard to the motion to dismiss. I reviewed plaintiff's response to that defense motion to dismiss. I do find there are a significant amount of documents that have been attached regarding this account that alleged to have not been paid. It's a credit card account of some sort. All of the addresses match up to the same John Hayes at the same address, 5141 Flagler Street, Flint, Michigan, 48532. Statements were going to that address. I see the card or the account was used on that occasions throughout the documents that have been supplied. Also find that there were some payments made on that account as well. Therefore, based upon all of the evidence at this point, based upon this motion to dismiss, that motion for summary disposition based on MCR 2.116. Is it a C9, C10? I guess I gotta look. C9, C10 motion. Mr. Jamal, this is your motion at this point. What, on this motion, did you receive a response to the motion for summary disposition?
I did receive a reply from the defendant. That was somewhat recently. I'm not sure if the court has that in the file.
Okay, I got it.
It's titled the reply. Let's have it opened here.
You should have it since it was filed at the courthouse.
What's it titled?
It's titled Respondent's Reply to Plaintiff's Response to Defendant's Motion to Dismiss.
Oh, I got that one.
Okay, that's the only one I see.
Okay. Mr. John Michael, is that the only response to the motion for summary disposition?
You asking me?
Yes.
Yes.
Okay. All right. I've got that.
That was the last response because that was I have not received anything more from them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. We show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount that's requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
And the amount, it looks like, just on the, I don't want the court cost, but it looks like the damages for the card, the account itself is $2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Oh, way in the back here.
The payment due date on that statement is February 17, 2025.
No, thank you, Jamal. I was just looking for the last, here it is. Yeah, I'm sorry, February